My name is Tom Atkinson, Director of Enforcement from the OSC. Today I have a panel for you. Directly beside me is Stephen Cohen. Stephen's an Associate Director at the SEC. Stephen rejoined the division in 2011 after spending 2 years as a Senior Advisor to Mary Shapiro. He's done a lot of work on whistleblowing legislation. We're looking forward to his comments. Next to him is David Cohen.
David
Conklin, sorry.
That's okay, he does it.
David's a commercial litigator from Goodman's with an emphasis on practice on corporate governance and business valuation. David represents shareholders, boards of directors, and entrepreneurs of both public and private companies. Dominic.
Yeah.
Dominic's from Lecture Fonte Tontis.
Let me help you out. It's a mouthful. Blackmar, Fonte, Tountous, and all. I'm the all.
So this is he deals in cases directly involving buy-side investor clients. He takes an active role in litigation, and he's got a great deal of experience working with institutional clients affected by securities fraud. Lastly, but not least, Jordan Thomas, who has been with us at our Whistleblower Roundtable Forum. He's chair of the Labaton Sutro Whistleblower Representation Practice. Did I do that right, Jordan?
Yes.
Jordan protects and advocates for whistleblowers throughout the world. He previously served at the SEC as an assistant director in the Division of Enforcement and has a leadership role in the development of the whistleblower program. So, this Wednesday, as Monica said this morning, we're publishing our final proposal on whistleblowing. Part of the proposal, I'm not supposed to be too specific. People are supposed to wait till the proposal is actually published. And I have four lawyers from the general counsel of the OSC staring at me now, so I'll make sure I don't go too far. So if a whistleblower brings the OSC a case where we successfully litigate or settle the matter, and total monetary sanctions are more than $1 million, they'll be eligible for $1.5 million, or 5 to 15% of $1.5 million, to be clearer. If we collect, however, on investor monies greater than $10 million, they'll be eligible for a greater sum, and I'll leave that for the final proposal, for you to see the final proposal. So this is different than the SEC model, which draws down their fund from, I think it's $400 million from the Dodd-Frank fund. Is that correct?
It's more than 400. It's
452. Obviously we don't have those kind of funds, so we're doing the best we can. And so let me start off by asking Stephen. Do you think, Stephen, there's an increase in the amount of funds available to harmed investors when financial compensation is provided to a whistleblower out of collections versus a fund? Thinking of the difference between the OSC fund and the SEC fund.
I guess, so I don't have any of my general counsel's office people here, but nonetheless, I will say that my views are my own and don't reflect the views of the commissioner and staff. Technically, yes, but generally, no. And by that I mean, and it just may be worth 30 seconds just noting, it's an eye-popping number, which we're proud of, but understand why so number one, we certainly thought and we're grateful for our legislature for providing a mechanism by which we can where we can have whistleblowers come forward and pay them without taking money out of the investor funds that would go to investors. I do think that's a terrific feature, and hopefully if your program proceeds and is successful, it's something that the Canadian legislature can consider. But sure, it was very important to us at the time to not take money out of that pool, but understand where it does come from, which is penalties and or disgorgement that we collect that doesn't otherwise go to investors. So it's important. I want folks to understand that, down south in America, they're not just throwing hundreds of millions of dollars at whistleblowers, but rather it was a quite carefully and calculated fund that was put together by recognizing that monies that we collected from wrongdoers was going to the U.S. Treasury and effectively pre-earmarking it, if you will, in a fund that will never go below 250 million, is that the number, Jordan? $300 million. And so I just wanted to make that point. So it's specifically money that is from wrongdoers, as opposed to money that in the first instance is being appropriated to the fund by our Congress. But that said, we're several years into the program now, and I oversee investigations that involve lots of whistleblowers. And I think I guess I would just say, I don't think it's the right way to look at it. So first, I would prefer a mechanism where you don't take money away from investors. But all things being equal, I applaud you all for considering the whistleblower program in the first place, because in my experience, some of the cases where we've had whistleblowers and where we've returned money to investors ranging from $1 million to hundreds of millions of dollars, these are situations where we would never have brought these cases without the whistleblower. So I really do think that it's important to put it in context and say, okay, if we are able to return money to investors and some percentage of that money is going to go to the whistleblower, if in some of these instances the investors were never going to get that money in the first place, it's surely a small price to pay. And I can tell you firsthand from my experience, we've brought substantial cases that, but for the whistleblower, we never would have discovered. And so that's my comment.
Jordan, do you think whistleblowers assist in finding funds for investors? Can you give me some examples or some thoughts on it?
Sure, there's no question that they do. In many ways, securities violations are like bank robberies. They're rarely one-man jobs, and they're almost always witnesses.
You really must be a plaintiff.
Well, I thought that you might say that, and so
They're bank robbers.
no, and, I thought you might say that. So, and other folks who do defense work. So, the University of Notre Dame and our law firm Labaton Suchard commissioned a survey of U.S. and UK financial industry professionals, and we asked them about their awareness of wrongdoing, and 47% said they believe their competitors were engaged in illegal ethical behavior, and 22% said that they had firsthand knowledge of wrongdoing in their workplace. So people know about wrongdoing, and they also know where money is. And this is important on a lot of levels because it's not widely known, but securities enforcement and financial watchdogs are able to secure monetary sanctions after a lot of hard work. But in many of these cases, they're not able to collect on those big numbers. At the SEC a couple of years ago, when you look at the annual report, it was something like 50 to 60% they were able to collect on. And even if that number was much higher, that means that we're not getting to the fruits of these illegal schemes. So having insiders help matters. Just one example from a whistleblower after the program came around. I represented someone who was able to identify a fugitive who was living overseas, and we gave the GPS coordinates to both their home and their work, and they were arrested. These are the sort of things that law enforcement officials didn't have before, that they can have in the future, and it's something that I hope that Canada will be able to experience also.
Just thinking about some of the comments about some of these horrible frauds from the last panel that we saw. What about whistleblowers and their effect of ongoing harm to investors?
Sure. Whistleblowers tend to bring information sooner. Too many times, financial watchdogs are stuck in a situation where the crisis has blown up, it's on the front page of a newspaper, and they have to build circumstantial cases from the ground up. With the assistance of whistleblowers, we're hearing about it, law enforcement and others, earlier, and able to stop the problem.
So Steve, what about the effect of being able to freeze funds or these interim measures? Has that been useful in terms of
Absolutely, it's huge, and I echo what Jordan said from my firsthand experience. There's no question that when we see these whistleblowers coming in and with regard to ongoing misconduct, or at worst close in time to the misconduct where we're able to obtain evidence. And then with our tools, when we get that kind of information, there's nothing more compelling when we go to a judge. We've done it as short as 24 hours. With the right information, some of these whistleblowers, excuse me, not only have their what they tell us, but they either have documentary evidence or other information that we can use to march right into court and get an asset freeze or a temporary restraining order or other things. To Jordan's point, although the gap isn't indicative of necessarily entirely of money that we could otherwise collect. In other words, a lot of times we can't get money because it's gone. But oftentimes there is money that can be collected, and the first period of time when a wrongdoer discovers that the government is after them is the most critical period. So for us to know about the wrongdoer before the wrongdoer knows we know about them is one of the most powerful tools in law enforcement. And when we have that information, and we can go into court and freeze the funds before it disappears into, I will not name the country where the money may go, but we're all familiar with them, and none of them are North America. You know, that's a really powerful thing, and that is the best way to get money back to investors.
Let's move over to the private side for a bit. Dominic, what about class actions? Are they utilizing evidence from whistleblower cases, or what's been the impact of whistleblowing in class actions?
You know, I'll take a sort of 30,000-foot viewpoint. I'm a securities litigator, and I do it on the civil side. And you know, our experience in some respects runs in conjunction with Steve is describing. The cases that have done best for retail investors and for other institutional investors are the cases that have been litigated by the world's largest institutional investors, most of them in the US. And I can tell you right now, because that is my client base, that what we need is evidence. And ultimately, no large institutional investor is going to step up, you know, to drive the class action bus on behalf of everybody else who has been defrauded in a true, you know, meritorious fraud situation, unless somebody like me presents them a very strong case as to why the case that they are getting involved in bears them no reputational risk. And getting evidence up front, getting it early has always been a huge help. It also, and this is specific to the US system, I'll refer to Doug Warnell from Systems and what's going on in Canada, but when I bring a case in the US, I have to get past the motion to dismiss with no discovery. That's just one of the vagaries of our system. That said, if I get past it, I have the threat of a jury trial hanging over defendants, so we tend to do very, very well, especially if someone like CalPERS or, you know, a Canadian pension system is running the show. But they're not in these cases unless they look good from the get-go. I mean, I have to be blunt. The world's largest investors do tend to be willing to litigate, to stomp around the peripheries of the capital markets, but they're not doing them on a speculative basis. Any programs in any country that are in place that are designed to bring solid evidence to the table early are a good thing in our mind in terms of the actual recovery that ends up in investors' pockets as a result of civil efforts. And if you put them in conjunction with regulatory efforts, the DOJ and the SEC and the OSC and the AMF are up to, you know, you put a solid case down with both regulatory side and civil side having that kind of, you know, firepower early, regardless of jurisdiction. Ultimately, the mom and pop investor benefits, and I don't want to be altruistic about it, but that's kind of the whole point. And so when we have an institutional investor driving the bus, they're there because they're not worried about whether they should be or should not be. And whistleblower programs have been instrumental to get people to come out early, to provide us the tools necessary to attract the people who should be running these cases.
Tell me a little bit about the relationship between the regulator and the class action lawyers.
I wish I had their evidence.
But sometimes, you know, I know in Ontario, for example, sometimes, you know, I think those are supposed to sort of work together, get the best result. And sometimes I don't think that always happens. Sometimes I think, you know, we're almost seen as in competition with the class action lawyers. I'm just wondering, what do you think of that relation? How can we improve it?
Well, you know, I don't actually have to disclaim like Steve does. I mean, I don't really care what my partners think, so I'll tell you what I think. At the end of the day, I mean, I really wish we had broad subpoena powers and could go in and get what we need to get past the motion to dismiss on every case. I think, to be perfectly honest, you know, my opinion would be that if you want to benefit retail investors who really are those who need protecting, you know, the world's institutional investors tend to be sophisticated and they tend to be able to absorb their losses because they have infinite horizons and have a lot of money. But you know, if regulators on both sides of the border could work in conjunction with at least the class action lawyers they trust and like, everyone would do a lot better. But the system is just not set up that way, and there are good reasons for that. You know, I think that I've been in cases where we have been perceived to be following on because the SEC or the DOJ have brought, you know, the good emails to the table, the good evidence. But I've also been in a couple of cases, one last year that ultimately the SEC followed us. They had a formal investigation going. We went out and settled it for a lot more money than I think the other side thought it was going to have to settle for. And then the SEC followed on and did quite well themselves. And I certainly hope they took a look at what we've come up with. So I think that even without a formal system in place, we can work alongside each other and do good, because ultimately you receive a fair fund and whatever we recover as one big pot. This is going to investors, and if it's the bigger the better in the meritorious case.
Tom, this is actually a very interesting contrast, because in the whistleblower context, you see the government and private firms working very closely together to kind of leverage the resources of a whistleblower. For instance, our law firm has former FBI agents, financial analysts, forensic accountants, and we hire private experts to help us build our cases and then work with the government to make them more effective and efficient. So this is the sort of thing that I hope you'll experience here in Canada, where you have essentially auxiliary law enforcement assistance, that your limited resources, if you're like U.S. Regulators, you wouldn't otherwise have.
Can I just add something? This is a different perspective. So, first of all, on the question of the relationship between the regulator and the plaintiff's bar, the focus of the discussion is about compensation. But I think that any policy that's being introduced by the OSC, including the whistleblowing policy and the one that the SEC has to be measured not only by what it may recover, but what its effect is on the actual practices of people in business. So that if people who are running public companies have an understanding that there is an incentive for employees to comfortably make anonymous provision of information that can provide them with a reward, the question can be, will that change behavior? Related to that, in order for it to really have a positive effect, I think that the announcement, which everybody will look forward to hearing about on Wednesday, will be more effective if the OSC has greater enforcement capability than it has historically to be able to actually run with the information that people provide them. But I gotta say, one of the major differences between thinking about what Jordan's saying and Dominic is offering from the American experience is this. The first threshold Dominic's mentioned that the plaintiff class action lawyer meets is a motion to dismiss that is brought on the strength of the pleading itself. And so the plaintiff firm, if they want to meet the high standard that is required by the courts for making allegations of facts that could give rise to a credible inference of an intention to deceive, are compelled to have a team of people to find witnesses who will give information to supplement what is in the public record. And for American plaintiff firms, therefore, whether it's a government congressional hearing, or whether it's a whistleblower or an SEC investigation that is announced that then provides information to the market and may actually serve as a first corrective disclosure that causes a share price, that body of information is critical to the U.S. claim being able to get over the motion to dismiss and then do a discovery stage where there may be a compromise that's reached in the interests of, I won't say lawyers, but the interests of shareholders. And that's how you get there. In Canada, it's different because we've got a different kind of regime that has a different standard for the initial review. So we don't have a motion to dismiss. Instead, the plaintiff has to put in evidence to demonstrate a reasonable possibility of achieving success. That is still a new standard for us to come to terms with, but defense counsel, if they're responding to it, can, in those cases that I've done where they've been successful, put in a very broad body of evidence that would actually be appealing to a plaintiff's lawyer to have access to in the United States. And the test that they're trying to throw at a plaintiff's counsel is to actually argue the case on the merits and to say there isn't a case here. And so the tension that the plaintiff lawyer confronts here, I think, is different than it is in the United States. The whistleblower will be helpful only insofar as they're augmenting information that somebody doesn't have. In a case I'm describing in Canada, the plaintiff's bar will know where to ask questions, but they should be able to get access to the information.
Having done some cases in Canada when I was at the SEC, my impression is that the regulators have a lot on their plate, and that the process that whistleblower attorneys can provide is, working on these cases in advance, they have a higher probability that they're actually going to be investigated and prosecuted. So they have, even in Canada, an incentive for plaintiff attorneys to build these cases well.
I think there's no doubt that one of the real problems is that when a regulator lacks resources, the opportunity for the private plaintiff's bar to make a difference, both in disciplining behavior and achieving compensation, is far greater. But I don't want to forget, you asked the question about the regulators and plaintiff's bars and whether they work together. You know, the largest, most recent significant fraud in Canada is Sinopharm. And you had a multi-million-dollar company that ends up being worth not even the paper that comes from the non-trees that exist. But here's the problem that's created by a Sinopharm. When you have an insolvency, so that you are limited to recovery against underwriters and professional advisors, in Sinopharm's case, Ernst & Young, or an insurance policy. Today, after 2 years, the insurance policy has been eroded by defense costs, and there have been no recoveries for investors. So that and one of the reasons for that is not just the defense costs of the plaintiff case. It's really the board fragmenting, having to deal with regulatory concerns. And you have a single incident, so you know, an insurer says, here's the policy limit, and now you're funding, again, just because it's signed for the forest of lawyers, to fend for these defendant directors and officers. By the time the lawyers are done, there's nothing for investors unless you can go to an ongoing business like an EY or an underwriter that has some exposure.
I just want to make a quick comment, because I think as you guys consider the OSC's proposal, you had noted the potential effect on all of this on businesses and how it might affect internal corporate behavior. And I just want to note it because this was the #1 issue that was debated at the SEC when our statute came out and we were debating our rules. And every corporate group in America filed comments with the SEC's rules and complained about their concern that this program was going to undermine the very fabric of corporate culture in America, and that all the whistleblowers now have an incentive to run into us and they don't need to be good corporate citizens. And we don't yet have empirical evidence on this from our experience, but I can tell you anecdotally, to a near certainty, that nearly 100% in my experience, and I'm talking over dozens and dozens of these, the whistleblowers report internally before they come to us. They are not running to us with all of their concerns, circumventing their internal corporate culture. They are coming to us still and nonetheless because they have reported internally first and nobody listened to them, or they were fired or retaliated against or otherwise. That's just my experience. I get the concern, but we're years afterwards, and I've yet to have, I do a lot of these panels and I hear the concern, but I've yet to have folks point to me instances where there was some offense to the company where if they had only heard from the whistleblower first, they could have rectified it rather than them coming to us. I'm sure that's true.
The Ethics Resource Center did the National Business Ethics Survey, and it came out with, in S&P 500 companies, only 8% of people reported externally first before reporting internally. And if you look at the broader spectrum of companies, I think the statistics were in the like 88% of people report internally first. So there's beginning to be a record of
Just before, I've got a couple of questions I just want to ask on that on behalf of the audience. Steve, for you, Dave, I understand there's about 3,000 complaints coming in the whistleblower program a year. What are the quality of those complaints, and how are they good? Are they overwhelming?
And the number's rising. I expect when the whistleblower report comes out in a month or so for fiscal 2015, you'll see a higher number than you saw last year, around the same increase, generally speaking. So I think it's important for people, we get this question a lot, and it's important for people to understand that the question to me is not what's the quality of the 3,000, it's what's the quality of information that we get, which after efficiently reviewing result in significant and serious investigations. And the reason I say that is we get over 15,000 a year complaints, putting aside the whistleblower complaints. well, like you all, we're reasonably efficient at going through complaints in the first instance and ferreting out what we think warrants attention. The number of more importantly to me is the number of high-quality complaints that we get, which often includes very detailed allegations of a kind we did not get before the whistleblower program, is increasing regularly. And it's those tips that we didn't get before because people want to participate in our program for a variety of reasons that I think is resulting in scores of highly impactful investigations and enforcement actions.
Do we have time for one more question, Cynthia? Do we have time for one more question? So what protections are for the whistleblower in the U.S.?
You know, the greatest protection is the ability to report anonymously. That is the best protection for against retaliation and blacklisting. And the commission has been very vigilant about protecting the identity of whistleblowers. And as someone who represents whistleblowers, that is what people are focused on because, you know, they are in the industry and they want, but beyond the ability to report anonymously, you have employment protections which allows them to go directly into district court as opposed to administrative proceedings. You get 2 times back pay. There's a longer statute of limitations than they had before.
Right, the OSC proposal is considering statutory protection and a private right of action.
I just want to say something, I mean, and from the perspective of a private litigant, the most damaging cases for shareholders, if I'm to generalize, are financial services industry cases. They just because of the size and market capitalization of the players involved and the the beating they can take within the markets. And any system that proves to a very high level person within the financial service industry that they can get out at the at essentially the rest of their career times X, and X is close to what they're going to get on an annual basis. It may sound like astronomical figures to lay people, and it is, but that's because the financial services industry pays that way. Ultimately, if you're going to get a managing director to sing about a bank cooking the books or screwing around with its depositors' money or whatever it is, it's never too much from my perspective, because you have to ensure that the people that come to the table with information are high level, that they matter, that they know that they were in the chain of whatever was going on. And the bottom line is that these days they're paid an insane amount of money, and so if they've got 30 years left on their career, and they know that second that they sing, they're done, anonymous or otherwise. Bottom line is they're out.
It's an interesting question to ask since you raised sign-on-virus. I mean, as people leave, think about this. If sign-on-virus, I hear about it a lot, obviously it's a very big case here, we have still ongoing. Imagine if the Canadian authorities could have learned about sign-on-virus before whatever assets they had were dissipated and preserved them. Just think about that. And think about
cases. There were no assets.
well, not forever, no, right? I mean, I get that ultimately.
Really, no assets. It's a unique problem.
Okay, I think we're out of time.
Take Nortel.
Yeah, take
That's
Nortel. Can't touch Nortel.
Okay, well, I want to thank the panel and thank Fair and Osgood Hall for inviting us.